Well, hello, hello, hello. Good to see everybody. Come on in, come on in. I mean, I know I just announced this morning, but I thought about something. I thought, you know what, that would be so fun to do. Because in a lot of these cases, over the years, things change, and then you learn new things, and you understand that maybe everything you heard at first may not be what's really may not be what's really going on out there. So that is why I have named our new little series. Justice Revisited Tuesday. So we'll only do these on Tuesdays, and we'll just do cases that are old and maybe we need to revisit because things have happened in these cases over the past 20 years, or something has recently happened that makes a change in the case. And in this case, Brenda Andrews is exactly what this is. So hang on just a second. So we're going to just talk about things that most people don't talk about, right? It's not just the crime, but like the system behind this crime. You know, evidence that should have been protected wasn't. Testimony that should have been grounded in facts was not. And decisions that should have been fair, unbiased, and lawful may not have been. Lots of controversy on this one. So what I'm going to tell you is I'm going to tell you about this case, and it's a little bit disturbing, and especially for women, it's very disturbing. So trigger warning already. It's controversial. It raises questions that the courts themselves are now being forced to deal with because it's out in the open that this is exactly what happened in this case. So this is it's not just a case, but it's a case to open our eyes to things that can happen in court, has happened in court, even though it's technically not legal or not allowed, but it happened. So let's go ahead and give our fair use disclaimer, get that out of the way. This live stream includes commentary, analysis, opinion, and discussions protected under fair use for the purposes of reporting, education, criticism, and public interest. All individuals discussed are presumed innocent unless proven guilty in a court of law, and any allegations mentioned are allegations not established facts. All media shown, including video, audio, documents, and images, is used transformatively with added context, explanation, and critical review. Nothing presented here is intended to defame, mislead, or assert guilt outside of official legal findings. So you can go to Anyway, that is our fair use disclaimer. So here we go. Now, let's go on back over here and we'll start talking about what we're going to talk about. So, the Supreme Court ruling in this case was very important, and this just changed the other day. How do we go from the Sunday school teacher to death row? Think about that. You know, everybody knows her. She knows everybody. Right. How does this happen? And this is old. So, it's it it's kind of a let me show you a little bit of something off of YouTube. Hey Leslie, how you doing, girl? Good to see you. I know I didn't announce it till this morning. It's okay, but anyway, I'm so glad you came in. Thank you so much. This is a very strange case, and how this happened and what's happened to this person as she went along is very disturbing. Especially some of the comments made in court that I was shocked when I actually heard it. We're actually going to listen to the audio from the Supreme Court oral arguments because they don't show it, but they will provide an audio in Oklahoma. So we're talking about an Oklahoma case. Let me get my tablet over here so I can give you a little more information here. So this is in January 2026, they had a hearing and they just put out the opinion and they upheld her original charge or her sentence. So she is on death row. She's been fighting this for 20 years. So she's been on death row for 20 years herself. And currently, she is the only woman on death row in the state of Oklahoma. So that is what we're going to talk about. So let me show you a little bit of this. I'm going to give full credit. Hang on a second. So this is from High Time Crime. Let's go ahead and give full credit to them. Okay. I got to find... I think it's this one right here. Okay, all right. So let me give full credit to, oh shit, start. High Time Crime. I'm sorry. I need to give full credit to High Time Crime. We're only going to play a little bit of this so you can see exactly how we went from Sunday school to death row, because that's a long hurdle. It's a long jump, isn't it? Okay, I don't think it's not gonna work, okay. Yeah, again, this is so weird because my little shift key, sometimes it works and sometimes it doesn't. It's just driving me insane. So let me share my screen. Crime high time. Okay, here we go. Let me share the screen right quick so we can all see the same thing. Oh, no, here we go. Stop, stop, stop. What is it trying to do? Oh, I don't know why I get nervous every time I come on. We have done this how many times? I have a lot of videos. I don't know why it makes me nervous, but it still makes me a little bit nervous. So this is from High Time Crime, and we're going to use this under fair use. So let me set this up, and let's start playing it. Okay, here we go. And,
Andrew family.
okay, show this.
Hello, friend, and welcome to High Time Crime.
Okay, I'm
My
going to get
name's
his,
Joel,
I'm going to
and
drop
on
his
here I specialize in true crime
channel.
and also speaking Spanish.
Hang on a minute.
Hola. Okay.
Right, put it right there so I can, let me get his, so I can share this copy. I figured out how to do this after yesterday's debacle about not knowing how to go and get the, anyway, here we go.
It's a lie.
Okay, here we go. Let's get over here to where he starts talking about this particular
Father
case.
to
There
his
you go.
two children, Tricity and
Here we go.
Parker, and he was
And
an
this is the
active
channel
member
we're
of
using.
North Point
Here we go.
Baptist Church. His faith was incredibly important to him and evident in his regular church attendance and his passionate involvement in missionary work in South America. His wife Brenda was even a Sunday school teacher. Overall, Rob was a loving father, a great guy, and a successful businessman. He and Brenda had met at a public school when Brenda was a
All right. I just wanted to play that for a moment so we can discuss how we go from the Sunday school teacher to death row. So let's get on down here. So this Brenda Andrews, she's the only woman that's currently on Oklahoma death row. Now, Brenda Andrews was the Sunday school teacher, a mother, and a woman whose life, just spiraled into a storm of accusations. There was insurance policies and a murder that the prosecutors claimed she helped orchestrate. Her husband, Rob Andrews, was shot in the garage of their home in 2001. Now, Brenda said that two masked intruders attacked her or them, and that prosecutors said that Brenda's boyfriend, James Pavot, staged the entire crime. Now, let me tell you something about James Pavot. James Pavot was also an insurance salesman, and he is the person that sold them the insurance policies. Think about that for a second. And now these insurance policies were $800,000. Okay, so this case has been so controversial because of some of the statements made during the trial that were so improper. But you know what? The Supreme Court did not allow that to change her sentence, even though it's calling it they're not harmless. Yeah, not harmless statements. That's what they're saying. It would not have changed the case. But I've considered, when I get to it, I'll tell you, because it's disgusting to me. But anyway, so for years, Brenda's case has been so controversial, not just because of the evidence, but because of the way the evidence was presented. Okay, so now let's get on over to that part. This is when the case becomes explosive. Prosecutors spent significant times focusing on Brenda's clothing, okay, her sexual history. Bing, bing, ding. All right, that's one of the important parts here, the sexual history. What has that got to do with it, right? Her parenting, and her alleged affairs. Even displaying, okay, this makes no sense, even displaying her thong underwear to the jury. Why did the jury need to see her thong underwear? What difference does that make in this case? Makes none. I think it's completely disgusting that they did that. She was not a victim of rape. There was no reason to show that to anybody. She's the perpetrator, right? Supposedly. So the exact issue that the Supreme Court addressed to support, okay, so anyway, the Supreme Court did address this in their audio recording, and we are going to listen to that in just a moment. So let's get over here to the oral arguments. Okay, but first, well, let me show you something over here first. Okay, okay, let me get to it right quick. Okay, we're going to go to the oral arguments. Let me change my screen so you can listen to this whole oral argument and how this came about and the discussion on this, her being sexualized by the prosecutors and the statements they made in her trial. Now she's on trial for murder. How does this make sense? It doesn't. Here we go. Let me share the screen. All right, guys. Now, there is no video. We can only listen to the oral. I'm so sorry about that. But this is going to be full credit to the Court of Appeals. Okay.
15-6190, Andrew V. White. We've set aside a half hour for each side, but this is in court, and I'm not going to be that strict about time as long as you're saying new and interesting things. So, Mr. Greenfield, Ms. Greenfield.
Let me see if I can make that bigger. Well, there's no reason to make it bigger, right?
Good morning, Your Honours. Good morning, Mr. Lockett and Ms. Crabb. I intend to reserve about 5 minutes for rebuttal. From the outset of Brenda Andrews' capital trial, the state introduced evidence grounded in stereotypes.
Now, hang on. Let me just tell you this. You got to listen carefully because this person has a different accent, and sometimes it's hard for me to understand the words she's saying. So I'm gonna make it a little louder and just listen a little carefully. Okay, here we go. Let's get back on it. Here we go.
About her as a wife, a mother, and a woman. The state repeatedly invited jurors to envisage her cleavage and clothing, picture her adulterous acts, and even infer guilt from the style and colour of her underwear. And at the penalty phase, prosecutors wielded this evidence to foreclose any meaningful consideration of a life outcome. This case is as extreme as it sounds. Ms. Andrews' case is back before you because the Supreme Court recognised that clearly established federal law prohibits the state's use of unduly prejudicial evidence that renders a trial fundamentally unfair. Stereotype-based evidence like that presented here surely fits the bill. Ms. Andrews' trial was fundamentally unfair at both the guilt and penalty phases. At the OCCA, Judge Arlene Johnson clearly understood that Ms. Andrews' claims fairly presented the impact of sex stereotyping evidence, writing that much of the state's evidence had no purpose.
I agree 100%. There was no reason for it. It was improper, but I am really shocked that she did not get a new trial with all of this that's fixing to come out when you listen to this oral argument. You know, we have to stop every once in a while for, fair use. So anyway, I'm going to stop right there before she really gets into the meat of what happened here. Here we go. Okay.
Other than to hammer home that Brenda Andrews is a bad wife, bad mother, and a bad woman. Indeed, judges on every panel considering this case have been disturbed by the sex stereotyping evidence that pervaded Ms. Andrews' trial at both phases. I will address the impact of this evidence at each phase in turn. So turning first to the guilt phase, the state tainted Ms. Andrews' entire guilt phase trial with its use of sex stereotyping evidence. It anchored the case in tropes about her as a woman, about her sexual behavior. From the outset, from its opening argument, the state made clear what it intended this trial to be about, and then proceeded to do exactly that, opening its case with pastors who spoke about Ms. Andrews' adultery. The very first witness for the state explained to the court that adultery is against the teachings of the church.
Can I ask you a question? Don't we need to evaluate if we apply 2254 D1 under Wellman versus CDOC based on the arguments that were presented in the Oklahoma Court of Criminal Appeals on direct appeal? Do you agree with that?
Yes, Your Honor.
And in the direct appeal, there were no arguments, nor did John Carlson make any arguments when it was originally before the panel about the testimony of the three pastors. Is that a problem for you? How can we determine that the OCCA's determination on sex stereotypes was unreasonable under Payne and clearly established federal law when the Oklahoma Court of Criminal Appeals didn't have the benefit of the argument that you're very well presenting to us?
Thank you, Your Honor. So this argument, the claim is exhausted.
No, I understand that the claim was exhausted, but I'm not asking you about exhaustion. I'm asking you, under 2254 B2, even if a claim is unexhausted, a habeas court can deny the claim on the merits, correct?
Yes.
And so assuming that it was exhausted, do you agree that with Ms. Crabb that the Oklahoma Court of Criminal Appeals did adjudicate this claim on the violation of a fundamentally unfair trial on the merits? Do you agree with that?
Yes, Your Honour, all parties agree that this claim has been adjudicated on the merits. And with respect to your question about the pastors, to the extent that the claim now we include additional record citations, additional examples, the nature and substance of the claim has not changed. And so in providing additional examples, the claim now we're simply adding colour to a claim that was presented below and that everybody agrees has been exhausted. And so at the OCCA, the claim that the OCCA heard was grounded in evidence about slurs used against Ms. Andrew, the word Hoochie, for example, in...
Wait, take that.
And with respect to your question about...
Okay, did you hear what he just said, using the term Hoochie? Really? That is degrading. I mean, it doesn't matter it doesn't matter what their crime is. They don't deserve to be degraded by the prosecutor and talked about as if they were. I find this whole thing so disturbing. I am still in shock that she did not get a new trial. It is ridiculous the things they were allowed to say. We'll keep going here.
Pastors. To the extent that the claim now we include additional record citations, additional examples, the nature and substance of the claim has not changed. And so in providing additional examples, the claim now we're simply adding colour to a claim that was presented below and that everybody agrees has been exhausted. And so at the OCCA, the claim that the OCCA heard was grounded in evidence about slurs used against Ms. Andrew, the word Hoochie, for example, in...
Wait, take that. I'm surprised. That was objected to and the judge sustained the objection to the use of Hoochie. Isn't that right?
That's correct, Your Honour, and the comment was not struck. So
that's your complaint, is it wasn't stricken, even though the judge said the objection is sustained.
The judge said the objection is sustained and the jury still heard the word and the word was not stricken from the record. In addition, the claim before the OCCA talked about evidence about Ms. Andrews' cleavage that came in through David Ostro, a witness who presented testimony on the third day of trial. There was evidence about her dyeing her hair red. The claim was premised on many of the themes that we are discussing today, and that has been presented to this panel. And in adding additional examples, the claim, we're adding more colour to that. And that doesn't render the claim changed or different if there is not new evidence being presented. Everything that is before this panel was before the OCCA. Everything is drawn from the record, and they had a full and fair opportunity to adjudicate that claim based on the record. Further, the OCCA was required.
How was it before the OCCA if there was no complaint that the evidence was inappropriate at the time? The specific evidence, if there was no mention, as Judge Bacharach was asking, about the impropriety of the testimony of the ministers and things like that, how was it actually presented to the OCCA? They weren't asked to consider that evidence in determining whether it was an unfair trial, were they?
They were asked to consider that evidence, Your Honour, because
How?
Because they had to evaluate, under the OCCA's own jurisprudence and under federal law, the OCCA had to evaluate the evidence that was enumerated in Ms. Andrews' brief in the context of the trial. And the context of that trial is sex stereotyping evidence that came in every single day. For example, the claim before...
Was there even an argument that there was sex stereotyping evidence?
Yes, Your Honour.
That argument was made to the OCCA.
That argument was made to the OCCA. Ms. Andrews' brief before the OCCA, in talking about evidence around her affairs, in talking about evidence around her clothing and hair, she argued that that evidence reduced her to a venal caricature in the eyes of the jury. That's at page 42 of her brief. She argued that this evidence made the trial more a referendum on her life. That's also at page 42 of her brief to the OCCA. She argued...
You know what? And I understand what she's saying, but let me ask you a question. This is kind of important. I want you to think about this too. If a jury is shown a woman's underwear during a closing argument, not because it proves anything, but because it makes her look immoral, because you're in the Bible Belt. Now, this happened in the Bible Belt in Oklahoma. Is that justice, or is this just manipulation? Now, the Supreme Court says this matters, and they say the lower courts were wrong to dismiss it. However, they do not give her a new trial. But anyway, here we go. Let's keep going. I'm so disgusted by it. It's shocking, actually. It's shocking.
Argued that this evidence was presenting her as a bad person because she had affairs, and arguing that the evidence was presenting to the trial antiquated beliefs about the appropriate behaviour of women. So while we agree and accept that Ms. Andrews does not use the term sex stereotyping, she does not use that particular label in her briefing before the OCCA, the claim was clearly presented as a claim grounded in sex-based stereotypes. And we need look no further than Judge Johnson's dissenting opinion at the OCCA to see that that was the case, because she clearly understood what was being presented to the court there. She clearly understood that this was about evidence painting Miss Andrews as a bad woman. First paragraph of her dissenting opinion talks about how much of the state's evidence had no purpose other than to hammer home that Brenda Andrews was a bad wife, a bad mother, and a bad woman, and that a defendant should be convicted, if at all, of the crime charged and not of being a bad woman. I don't think there's any way to read that dissent other than understanding the claim that was before her, which was about the evidence of sexualization of Miss Andrews, the evidence of her hair, of her clothing, of her appearance, of the sex acts, of long history of her sex life, that was about stereotyping, about painting her as a bad woman and inviting the jury to infer guilt because she...
You know, Leslie, you're right, and that's what I'm saying. She was sexualized by the prosecutors in a case which she was being tried for capital murder. Now, how do you go from this is a case about capital murder to them sexualizing her to the jury and expect to get a fair trial? Because now in the Bible Belt, you got to remember, you know, immoral, you shouldn't do those things. Because she was having an affair. That is out there. That's true. And it wasn't her first affair. Okay, so they know this. But what has that got to do with passing her underwear around? I don't understand that, and I never will. Let's keep listening. It is fascinating.
She is a bad woman and acted as a bad woman and therefore had the propensity to act as a bad woman on the day of Mr. Andrews' murder.
Why wasn't it briefed and argued that way then? Would have been simple to do what you're describing now.
I think it was briefed that way, Your Honour, and we have the luxury here of multiple pages devoted to this single claim, because that's the only claim that's come down on remand. Nearly 20 claims were presented to the OCCA, so naturally I think it's inevitable that there were fewer examples. Even in our briefing here, we didn't include all of the examples that we found in the trial transcript of this kind of evidence due to page constraints. But I think the argument that she makes in her brief makes it very clear that this was what was presented to them. And Judge Johnson's dissent makes very clear that this is the claim that they considered and they denied, unreasonably so. And so the fundamental question that now is before this panel that has come back on remand is whether this unduly prejudicial evidence rendered Miss Andrews' trial fundamentally unfair.
Let me ask you about the nature of the evidence a little bit. The state could put on evidence of motive. You agree that that's appropriate?
Correct, Your Honor.
Sex is sometimes a very strong motive that causes people to do very bad things. You agree?
Yes.
So why wasn't the relationship between Ms. Andrews and Mr. Pavad relevant? And that's what the pastors, I'm not sure what the clergy were referred to as. That was the nature of the evidence there, showing this very strong relationship. This wasn't just a couple who were friends, they taught Sunday school together. Why the heck would they murder anybody in that circumstance? Why wasn't the relationship between the two relevant? And if the pastor said they're acting so affectionate toward each other and so on, that it was scandalous in the church. Why is that not relevant?
I think the Supreme Court in its second footnote addresses this question somewhat as well. The We agree that the fact of the affairs has probative value here for all the reasons that you've explained, Your Honour. It's the detail that is elicited from witnesses about those affairs that puts this trial over the pale. It's the detail about the sexual relationships, about where this happened, about...
Well, speak specifically about what the first witnesses talked about. I'll call them the pastors.
Mhm.
Yes, they were talking about what was done in public at church, essentially, right? Why was that over the top? Why wasn't that relevant? Could they just say they seemed very affectionate toward one another and leave it at that? Is that all the government's allowed to do?
They could have said that, Your Honour. They could have said that there was behaviour between the two observed and left it at that. But the prosecutors elicit testimony beyond that, inviting the pastor to condemn adultery as the first witness in the trial. This is on the first day of trial. And the problem here arises not from, less from looking at each individual piece of evidence, but looking at the cumulative impact of this evidence on Miss Andrews' trial as a whole, which is the essence of the fundamental fairness inquiry here. Building on the testimony from Pastor Siner, who testified about how adultery is a sin and must be condemned as the first witness, the state built on that with further testimony about Miss Andrews.
Now think about this. Think about that statement you just heard. Must be condemned. You've got a panel of juries over here, and they all live in this little area, and they all, they're all going to church and everything, and they know what the Bible says, and they know what the sins are. So you're already misleading these jurors with this over information and condemning her before you've heard any of the evidence. Now, whether she did the crime or not, it matters, but some of this does not matter. But anyway, here we go. It's just sickening. It is. Okay, let's go.
Andrew's previous affairs, adding detail with the testimony of Mr. Higgins, who was presented on the second day of trial, that went into extensive detail, to an extent that it makes for very uncomfortable reading, and that's words on a page.
It was relevant for him to say that she had told him she hated her husband and wished he were dead. You agree?
Correct, Your Honor.
That's a remarkable statement for a woman to say to a guy. Wasn't it relevant to bring out their relationship and how they met? That was done with all the other witnesses. They were told, okay, how do you know these people? How did you get involved with them? Why was that totally irrelevant with respect to Mr. Higgins?
So we agree, Your Honour, that the statements, I think there were 3 statements in the context of Mr. Higgins's entire testimony that have probative value, the one that you have isolated there in particular, and some context about why she might have shared that with this person is totally appropriate. But where did you have sex? Car. Whose car? My car. Where else did you have sex? Motel. She put the motel key in his hand. What was she wearing? How did they meet? She rubbed up against him. She touched him. She placed the key in his hand. This testimony is painting a picture for jurors. This goes far beyond establishing the nature of the relationship between the two. And Miss Andrew even stipulated to the existence of these relationships at page 338 of the trial transcript. But the gratuitous detail there, that's really painting this picture of Miss Andrew and how exactly they had sex and what she was wearing at the time and how many times they went to the motel, that far exceeds anything that is necessary for the prosecution to establish the nature of that relationship there. And the same was done with Mr. Pavat as we move further on in the trial, on the 12th day of trial, with witness Dean Gigstad, who was invited on the witness stand to have a reenactment of sorts of an encounter that happened with Mr. Pavat. By that point, the existence of the relationship between these two parties had been well established, and there was no dispute about that. There was no dispute that this was a sexual relationship.
So, okay, so they've established that she had an affair with Mr. Higgins, okay, and now they're going to move on to talk about her affair with Mr. Pavat. Now, I will tell you, because we're not really talking about him, but he is part of this. Eventually, he confessed that he was involved in the murder with her, okay? So, I'm giving away some of the details, but it's kind of important because, you know, she's been saying she wasn't guilty for 20 years, but she was actually in an affair with Mr. Pavad. Okay, so here we go. We'll keep letting this go. Okay, here we go.
But eliciting testimony from his daughter to speculate about how many people Miss Andrew may have slept with added nothing to the nature of that relationship. Having this reenactment with the witness of how close Mr. Pavad and Miss Andrew might have been on the decking, is again inviting jurors to really picture this, to paint a picture in their mind. And that's the impact of so much of this evidence. If I were to hold up a pair of women's underwear in this courtroom today, I'm fairly sure that that's the only thing that this argument would be remembered for, because it's incredibly emotional, incredibly emotive. And this isn't a theoretical exercise. That happened in Miss Andrews' trial.
I didn't mean to point at you, and I don't mean to interrupt you, so I apologize. But let's take your hypothetical that you hold up a pair of thong underwear, and that may be a memorable image to us. But let's take that example. If this is a direct criminal appeal, and you hold that up, and that had not been argued in district court, but you raise that, and then your argument is that the federal district trial, maybe conducted in this courtroom, was so laden with inappropriate sexual innuendo and the like, and then you hold that up, and that is part of the record, but that was not presented in district court. And let's say hypothetically that the standard of review in a direct criminal appeal, and this is a hypothetical, is whether or not the district court unreasonably determined what, made a conclusion based on what the evidence was presented. Wouldn't it be unfair, in a sense, to say, well, the district court failed to consider the fact that the defense lawyer held up a pair of thong underwear and that wasn't the transcript. It was never mentioned in the transcript, but we are privy to that as an appellate tribunal. And isn't that the problem that was enunciated in Wellman versus CDOC, that when a claim is adjudicated on the merits, that Oklahoma Court of Criminal Appeals does the same thing that we do, that every single appellate tribunal does, and that is the party presentation rule. We adjudicate issues and arguments based on the evidence that is elucidated. And so if we credit what you're saying, that these three pastors were in the record, not mentioned to the Oklahoma Court of Criminal Appeals, that let's say to follow up on Judge Hartz's question, about the Hoochie comment, Mr. Oslow's testimony, and nobody has presented, and it's sustained, maybe not stricken, but isn't at the end of the day, our inquiry under.
Want me to tell you what the exact term was? And this is Mr. Higgins, I believe, is the person, because in Cornell Law School, they talk about this. This is one of the cases they talk about in law school. That's how big of a deal it was. But during Brenda's trial, prosecutors produced male witnesses who testified that Brenda was a sex-crazed hoochie who would stop at nothing to satisfy her desires. The evidence included one man's opinion that Brenda once wore a dress that was so tight and short, it showed a lot of cleavage. Now, this is in the trial transcripts. It's there. It included another man's opinion that she wore sexy, provocative outfits. And then there was extensive details about the places and times in which she engaged in flirtatious behavior, which she had engaged in, that and other men, as well as testimony about her affairs, including the relationship that ended more than 17 years before the crime. Why are we going back 17 years before the crime? After reviewing this evidence, Judge Arlene Johnson of the Oklahoma Court of Criminal Appeals concluded that Brenda Andrews had been sentenced to die based on evidence that has no purpose other than to hammer home that Brenda Andrews is a bad wife, a bad mother, and a bad woman. Now let's listen to the rest of this oral argument here. All right.
2254 D1, whether or not the Oklahoma Court of Criminal Appeals unreasonably adjudicated the arguments that were presented to us based on the arguments that were presented to them, just like we're not going to go looking for issues under the party presentation rule based on the arguments, and we're going to confine ourselves to the arguments that you and Ms. Crabb present.
Absolutely, Your Honour. The underwear in this situation was presented. That's Proposition 7 that was presented to the
I understand.
OCCA.
That was part of my hypothetical. I know Mr. Geiger raised that. Yeah.
I see.
Well, let me ask one. I thought the only source of the fact that of the allegation that he held it up to the jury was because of something in the newspaper. No, you have record evidence of that?
Well, I think a reading of the record is clear what's going on. He's saying, would a grieving widow wear this? Would she wear this? And later says, would a widow...
You're right, Leslie. What does that have to do with the murdering of her husband? It is like, this is the worst. It's biased. I mean, they're presenting that they're biasing her. She doesn't have a chance in hell from the way this is being presented that she did anything right, because she's an immoral. She's broken the rules of God. Okay, in the Bible Belt, where she's sinning, right? God Almighty, this is terrible. Here we go.
The grieving widow would take her thong underwear.
Okay.
The colors of the underwear was never...
The colour of the underwear is from contemporaneous reports. Yes, that's true. But the words thong underwear in the transcript, it's clear that's what he's talking about. And Exhibit 313 has photos of this evidence that went back to the jury.
You think that was not at all relevant to the government's argument that this wasn't a grieving widow who needs to escape and get away from things? That's what it was offered for at trial. You don't agree that's at all relevant to that allegation?
No, Your Honour. I think that no fair-minded jurist could conclude that a trial that invites a jury to infer guilt from the style of woman's underwear could be fair. There's no possible inference there from a piece of underwear.
Counsel, what do we do if the OCCA says a piece of evidence is relevant? That's beyond us, isn't it? Is that not conclusive on us? State court ruling on state rules of evidence that are akin to the federal rules do not present a federal question for us, do they?
That's right, Your Honour, and we agree with the state that...
All right, I'm sorry, your time's running, and I know that you may get some extra, but once we say that, I'm trying to figure out how to analyze this. We say, here are the relevant facts, which we take as relevant because the OCCA said so. And then here are the irrelevant facts that everybody seems to concede, including that. And then our charge is to determine whether or not that evidence, that irrelevant evidence, not the relevant, including the affairs, but the irrelevant evidence is so unduly prejudicial that the trial was fundamentally unfair. And then we call, in weighing that, we determine how strong was the evidence. If the evidence was overwhelming, then presumably the prejudice diminishes with that. Is that the way you would analyze this too?
I think with respect to looking at what the erroneous evidence is here that the panel is considering in weighing the fundamental fairness question, there are three ways of looking at that. First, starting with our clearly established federal law, Payne says that the issue here is unduly prejudicial evidence that renders a trial fundamentally unfair, and the OCCA was presented both with the state law question and with the due process question, which deals with unduly prejudicial evidence. Second, under Andrew versus White, the Supreme Court has given really clear instructions to this panel in how to look at the evidence on remand, that we're looking at the disputed evidence and factors within that.
Is it the disputed or is it the irrelevant evidence? You dispute relevant evidence, don't you? What the OCCA said was relevant evidence.
So I think, Your Honour, even if we take just the irrelevant evidence, Ms. Andrew wins. And to your question, Judge Bacharach, as well, even if we're just looking at the evidence that was specifically enumerated before the OCCA, Ms. Andrew prevails.
When you say she wins, are you saying that this panel should say there was a 14th Amendment violation, that in fact she received a fundamentally unfair trial?
Yes.
Or are you taking the extra step, which I think is required, that all fair-minded jurists would say that the OCCA's determination, and I assume you're conceding that it adjudicated the 14th Amendment question.
Yes, Your Honour.
All right, that you would concede that by adjudicating that's where you're left, that all fair-minded jurists would have to say the was unreasonably applied pain. And that seems like a very tall order, especially in view of the previous history of this case. Could you respond to that?
Yes, Your Honor, because the concededly irrelevant evidence here includes a gendered slur. It includes evidence about her hair color. The state in footnote 6 of its response brief has now conceded that evidence about Ms. Andrews' hair and appearance is irrelevant. The evidence that the OCCA also found irrelevant includes testimony about her cleavage, about a dress that was tight and short.
I concede the list, and we all have seen the list, and you can rattle it off, and I...
You know, it seems as though the justices were very uncomfortable in talking about these parts of the trial, or, you know, what was actually presented. They seem like they don't really want to hear the actual words that were used. And I mean, why? They're supposed to rule on this and be fair and unbiased. Why would they not want to discuss exactly what was said? Because the jury was allowed to consider such evidence in violation of the fundamental rule that a defendant must be convicted if at all of the crime charged and not of being a bad woman. This is Judge Johnson, okay, saying these things. So I just think that, hold on, dropped my little mouse over there. I just think they just sound like they're not really listening is what I'm saying, because they don't really want to discuss the actual words. Here we go.
I will nod my head affirmatively that a lot of irrelevant, prejudicial, maybe evidence came in. But that's not really getting where I need to be, which is that focusing on that totally ignores all the evidence of guilt, and there's a lot of it. And so if you say that this irrelevant evidence prejudiced her, and it's a tough standard, so unduly prejudiced as to give a fundamentally unfair trial, that's a lot. For you to say that, first you have to address the overwhelming evidence, or the evidence of guilt that's relied on by the panel previously, as well as the jury in convicting. You have to acknowledge that. And here's the tie that I'm looking for, and where I'm looking for help from you, is I get that you say this prejudicial information, evidence to the jury could have worn away on her credibility or made the jury not like her, and therefore tilted the balance of the jury's deliberation in some fashion. But where I'm left is confused how that fits on anything that mattered in this case, whether it's the brake lines, or it is the telephone calls, it's the shotgun, it's the gig stats where the ammunition is found. None of that has anything to do with her credibility, does it? What is her credibility that this is undermining that made that big of a difference in this case? That's where I'm stuck.
Respectfully, Your Honor, I disagree. I think her credibility was hugely important to all of that.
On what? On which one? How?
So
the shotgun. How was it important for that?
Because all of this was contested evidence. Ms. Andrew contested everything in this trial, and so her credibility, the case rose and fell on her credibility as a counter-narrative, as a narrator, as somebody to present a testimony.
What is contested specifically other than two masked gunmen instead of Mr. Pava?
So, for example, the brake lines, Your Honor, that you mentioned, she had an alternative narrative to that, and that narrative stood no chance. This was compounded by a lack of mitigating instructions. The trial court was given, the jury, was given no way to understand permissible inferences that they could draw about her being a bad woman and a bad person, and compounded by her excluded witnesses as well.
That's my point, is you have to acknowledge the overwhelming evidence on that too, which is, it's not just she said, I didn't have anything to do with the brakes, and the jury thought, you're a bad woman, so yes, you did. There's a whole lot more to it than that. The telephone calls, the sequence, the previous threat, her mentioning to Rob before it was in the newspaper, hey, I saw in the newspaper that someone tried to cut your brakes. A lot of evidence of guilt there.
Yes.
That has nothing to do with underwear or bikini bottoms or whatever we're talking about, or hoochie or red hair. Just doesn't have anything to do with that.
I think looking at how the state presented its own evidence is really illustrative here of how this trial went. The state started, very first line of its opening statement, with this is about a controlling woman who liked to cheat on her husband, who had extracurricular activities. The state then...
Okay. Did you hear what the very first line was? A controlling woman who liked to cheat on her husband. Bam! Right there, they set the tone that she was horrible. She did not care about her husband. She did not care about her marriage. Look at all the things she's doing out there. She's sinning. Oh my God. You know, that was so wrong. It is extremely wrong. I mean, whether you're sleeping around or not does not mean you killed your husband. Okay? It just doesn't. Here we go. Oh, that's good.
Presented days of testimony about that.
Wrong.
And in closing, at both guilt and penalty phases, and at both bifurcated closing arguments here, the state chose to end with evidence of her affairs. And explicitly, the last things that the jury heard before they went off to deliberate at guilt phase and at penalty phase were about how she was a bad woman who was having affairs, in contrast to Rob, Mr. Andrew, who just wanted to love her.
Let me ask one question about that. When you're talking about closing, was there any argument to the OCCA about improper closing argument?
Yes, Your Honor, that's Proposition 13 before the OCCA.
And what were the things complained of?
The complaint of there was in Proposition 7 was the use of Ms. Andrews' underwear at closing argument, and in Proposition 13, they presented a due process violation based on a closing argument at penalty phase that invited jurors to conclude that she was a bad person because she invited workmen into her home.
Closing argument at the penalty phase?
Yes, both are presented to the OCCA. Okay.
With respect to the guilt phase, the closing argument, the only issue was the holding up the underwear. Is that right?
From memory, Your Honor, I think that that is one of two issues that were presented. Proposition 7 was divided into 7.1 and 7.2. I'm afraid I can't quite remember off the top of my head what was in 7.1. And I'm conscious of my clock ticking out. So if there are no further questions.
There are further questions.
Okay.
Go ahead.
A lot of questions, actually.
Yeah, but I want to hear yours.
Okay. Well, one of the things that I'm just a little unsure of from the appellate briefing is, and you mentioned Judge Johnson's dissent, partial dissent in the Oklahoma Court of Criminal Appeals opinion. Now, a lot of the evidence that you are relying on, and your predecessor, Mr. Carlson, relied on to impugn the death sentence was actually evidence that was presented at stage 1. And this is a little bit of a corollary to some of Judge Phillips' questions. With regard to the evidence that you contend was improperly elicited at stage 1 on guilt or innocence, don't you have, or do you have to satisfy 2254 D1 or D2 with regard to the introduction of that evidence at stage 1 before we can consider the issue that Judge Johnson addressed, and that is whether or not, even if it didn't necessarily undermine the fundamental unfairness of the guilt innocence determination, that it could have impugned the imposition of the death penalty because it only takes one holdout juror. But before we can address that, don't we have to ultimately determine that there was a violation of D1 or D2 with regard to the introduction of the evidence at the guilt stage?
So the instructions from the Supreme Court make clear that this panel is to consider the impact of unduly prejudicial evidence at both phases.
But how? Yeah, and I agree with you that they said that. How do we do that?
And so I think this comes back to the question of what is the erroneous evidence that we're looking at here, what is in that bucket, and what was the impact when considered in the context of the entire phase 1 proceeding and phase 2 proceeding. And so even if we just take the concededly irrelevant evidence, the picture that was presented of Ms. Andrew, the drumbeat that was reinforced over and over again throughout the guilt phase bled into the penalty phase. This was not a foregone conclusion at the penalty phase. The state's penalty phase case lasted half a day. It incorporated its guilt phase evidence and continued its attacks on Ms. Andrews' failure to produce tears when asked for, on her affairs, grilling witnesses about whether the fact she had affairs would change their opinion of her. So continued to base its case in gender-based stereotypes and in sex shaming. And at closing argument, the prosecutor continued to raise these issues. So even if we're only looking at the evidence that has been conceded before the OCCA and here, this still arises to the level of a due process violation, because no fair-minded jurist could conclude that a trial which was made about a defendant's sex life was fair. No fair-minded jurist could conclude that a trial that trafficked in gendered slurs.
It's because, okay, well, she's cheating on her husband. She's not a good woman. So she must have wanted to take his life. Think about that. Think about what was being told to these jurors by this prosecutor. He knew that this was not, he should have not been using that. He knew better. I don't understand. Sometimes I don't understand why well, I do understand it, because prosecutors want to make sure they win. So they go to the lowest, dirtiest thing that they can get away with to make sure they got those jurors in their hand. And that's exactly what happened right here. Here we go.
Fair, or that a trial that was focused on her cleavage, her clothing, her short skirt, her tight dress was fair. All of this evidence, as Judge Johnson said, trivialized the value of her life. The effect of stereotyping is to reduce, to flatten the defendant to a villainous archetype. And that's somebody on whom the jury could very readily pin the crime.
Who raised the issue of whether she was a good wife or mother?
The state argues that the defense opened the door to this.
Yes, when they asked, I think it was Mr. Nunley.
But this evidence started coming in far before that. Even the state's argument in its most recent round of briefing that the defense opening argument opened the door to all of this.
Well, it was a mitigator. It was a mitigator.
Yes,
I mean, the defense, Mr. McCracken and Mr. Muskowski specifically asked at stage 2 for a mitigating circumstance. I didn't mean this is, I'm not talking over Charles. It's just to put an exclamation mark on his question. You know, that was something that, that Ms. Fern and Mr. Geiger didn't do. They were responding to a mitigator that was elucidated by the defense counsel.
I think that argument becomes tenuous, Your Honor, when we think about what actually happened here and the nature of the evidence. It's not possible to open the door to prejudicial stereotyping. I think Buck versus Davis makes that very clear. The issue in Buck was a defense witness and testimony by a defense witness. And nevertheless, the Supreme Court concluded that that single comment grounded in the defendant's race rendered the proceeding unfair.
He was asked on cross-examination. Well, let me get back to another point I'd like to follow up. I mentioned this earlier on. You acknowledge that sex could be a motive.
That sex could be a motive?
Yes, for doing very bad things. People do it all the time, right?
Yes.
This offense, if she was guilty of it, was cold-blooded murder of a husband by a boyfriend and her working together. How could somebody do that? What would be the motive? Sex, in part. So you just say, okay, they had an affair. Lots of people have affairs without killing spouses.
Amen.
The evidence of the intensity of this relationship, the fact that they would act this way so inappropriately in public, in church, isn't that evidence of the intensity of the relationship between them, which might be relevant to determining whether this was enough to make these two do this evil deed? Why is that not relevant? Why don't you answer that first, and then I might have some follow-up questions.
And just to, I can see that I'm out of time.
Don't worry.
Great, thank you, Anna. So I think we come back to the question of what is probative and what is so prejudicial that probative value is outweighed here.
Well, sometimes probative evidence can be very prejudicial. That's what
it's the nature of it. Absolutely,
yes. And when you've got sex as the motive, how are you going to keep out stuff that is sexual?
And even if sex is the perceived motive or is what is being argued in a case.
So there's no other motive. Well, money.
I think there were other motives on the table here that were presented by the state and the nature of the relationship between the co-defendants being one of them. But that doesn't greenlight a trial to just be flooded with endless prejudicial testimony about
Well, and now you're going to mention hair and that stuff. I'm going to focus on the relationship between the two defendants. Why isn't any evidence of their publicly inappropriate sexual relationship? Why isn't any of that? Why isn't all of that relevant? Why does the government have to say, no, I'm not going to put on that because that's too damning of them? Why is that not the essence of the case in a way?
I think I may have misspoken, Your Honor. Our position is not that any evidence about the nature of this relationship is irrelevant and has no probative value. It's that the gratuitous nature of it doesn't get the jury
Why
any
is it
closer
gratuitous if it's about their relationship? There was gratuitous evidence. Everybody acknowledges that. But we have to look at that in light of what's already been introduced that's relevant. The fact that Mr. Nunley had an affair, and I think with Miss Andrew, I think that's one statement. There's nothing about where they had sex or anything like that.
So, okay, so all right, they've introduced 3 people, Mr. Nunley, Mr. Higgins, and Mr. Pravat. Okay, so she had affairs. That doesn't make her a killer, right? Now we do know that there was an $800,000 life insurance policy, so I can see where money would be a motivator. Wanting to have a life with this other guy would be a motivator. But she could have simply filed for divorce. Or was it in their little area that she lived in this part of the Bible Belt? Divorce was a no. You don't do that. It's till death do you part, right? Maybe is that what's going on here? Let's finish listening.
That was relevant because why the heck would she be calling this guy 40 times the day before she leaves town or whatever the specific facts are? So you want to know that they'd been very close at one time. That gets in. That wasn't inflammatory. It was an important point to explain their relationship. But that's been attacked repeatedly in your briefs when it seems to me that was totally relevant in that circumstance. So you have some of the sexual evidence seems to be quite relevant to motive here or to explain the relationship between a witness and Miss Andrew. And we have to look at the gratuitous stuff in light of that. I mean, it'd be hard to explain a relationship with Mr. Pravat without seeing her in a bad light for her sexual behavior. But that was quite appropriate. Or I'd like to hear what you say about what was wrong with that.
Yes, Your Honor. I think we're broadly in agreement that the nature, that the fact of her relationship has probative value. The fact that this was an intimate relationship has probative value. But we have to look at how this was presented in the context of the full trial, which is endless testimony about multiple sexual relationships going back to 1982, which is very attenuated time-wise, to build a picture of a woman who has this salacious sexual appetite and uses her sexuality in deviant ways to ensnare men or to lead men to their demise. And with respect to Mr. Pravat in particular, the nature of that relationship, understanding the relationship between the parties, we don't contest, that's important. But what was not required was speculation about how many sexual partners she might have had, about the reenactment that happened, testimony from Curtis Jones about how he was Twitter-pated with her because of their sexual relationship. It was reinforced day after day, and in the context of a trial that began with testimony about previous sexual relationships and ended with closing argument about 2-decade-old sexual relationships. And
on that, as far as, and again, that list of things that everybody has said are irrelevant, trying to figure out your position for sure, and now's my chance to find out. So let me ask you, are you saying, regardless of the volume of criminal evidence connecting her to a first-degree murder and a conspiracy to commit one, that if this quantum of that evidence comes in, that it is per se so unduly prejudicial that the trial is fundamentally unfair? Is that your position every time? that this happens?
Not every time, Your Honor. I think that's a very case-specific determination that the panel is undertaking here, weighing up how the prejudicial evidence affected the whole trial.
And the stronger the evidence of guilt, the less important this other evidence. Do you agree with that?
Not necessarily, because I think the Supreme Court has made clear that there are limits, and perhaps, like in the case of Buck.
Well, now you seem to be arguing for a per se rule.
No, I think our position, Your Honor, is that even in the face of inculpatory evidence, which of course there was in this trial, there have to be limits to what the state can do.
Okay.
And the nature, the tenor, the frequency of this evidence was such that the jury that it tainted the entire trial, compounded by other errors that are accepted by the OCCA.
A couple of questions. That first one, a hypothetical. Say that the evidence is even stronger, that a neighbor walks by and sees exactly what happens in the garage, and it's as the state portrays it, or has a video camera and videos the whole thing. Would you still be saying today this was a fundamentally unfair trial, despite that evidence too, because of all this salacious details just contaminated the jury's start over?
I don't think it's fair that he's putting it that way to her, because yes, there could have been evidence galore. Here's the thing I'm going to say: he could have produced evidence without ever speaking about her cleavage or the underwear or the fact that she had several affairs on her husband. He could have still found there was enough other evidence to find her guilty. So this is why I'm saying they did not need to bring that part into this, but the prosecutor knew if he did that, he was going to get a score. He's going to get a win right there, because in that area, she is the worst of the worst. Look what she's doing. And she was a Sunday school teacher. Are you kidding me? How could she? That's what I'm thinking. I wonder how you, right. Yeah, Leslie, right. Because he knew exactly how to take that into those jurors to get his slam dunk case, no matter what she had to prove. She didn't do it or she did do it, right? Because he's using that against her. Oh my goodness. Here we go.
Would that be your position? Or would you say that's enough evidence?
Mm-mm.
I think it might depend on the nature of the evidence presented, Your Honor, but it's certainly at the penalty phase, I think there would be, there's a discretionary inquiry. Turner versus Murray establishes that given the discretionary nature of that inquiry at the penalty phase, that there's plenty of room for bias to seep in.
And that's my second question, penalty phase, which goes back to my original problem. And I'm open, but you have to help me here. I see a disconnect. Grant you everything that you say on the irrelevant evidence, and why some of that was introduced is beyond me. But just the same, penalty phase aggravators, remuneration. She has the evidence of the insurance policies. There's an $80,000 joint account, so forth. There's nothing to do with her sex life or sex conduct or anything else. The second, especially heinous, atrocious, and cruel, nothing to do with all of the things that you're complaining of with merit, has nothing to do with it. So essentially what I'm hearing is, even though she was found guilty on strong evidence that this court has previously described as overwhelming, so what? It's a redo because this sort of thing just can't be permitted, even though it didn't have an effect on those aggravators.
I think due process demands more, Your Honor. And with respect to the penalty phase, it's not simply the aggravating factors. There's then.
Yeah, it goes back to our Constitution, right? And due process and the fairness in the trial. Everything that they should follow, and look what they're doing instead. I mean, a person's rights should never be dismissed when they're being accused of murder. Here we go.
Weighing that has to happen, and the jury has to ask itself fundamentally, is this person the worst of the worst? Is this somebody who should be eradicated from society? And Miss Andrews' case, she had no prior offenses, she had no violent history.
This was an awful murder.
Yes, Your Honor.
Okay.
And penalty.
That affects how jurors decide whether or not to impose the death penalty.
Absolutely, Your Honour. And there's so many factors that go into juries' determinations at sentencing phases, as this court has recognised, as the Supreme Court has recognised. And when this much bias floods a trial, we can't be certain that that wasn't what tipped the scales here, that wasn't the hatred inspired for her, the strong emotion from this sexualizing evidence, the picture painted of her from the outset of trial over the course of 5 weeks was not what tipped the scales here for jurors when deciding whether or not she should live or die. They didn't find the third aggravating factor, which may suggest that this was a close call, but future dangerousness is often something that matters to juries. Scholarship establishes that a lot. And nevertheless, they didn't find that aggravating factor. And in spite of the other two aggravating factors, there's still a weighing that happens at the penalty phase.
It is a...
Yes.
Okay. And I apologize for interrupting, but I do want to follow up on what you just said. So, you know, and I don't have a photographic memory, but I think you said something to the effect that we can't say that it didn't tip the scales. Isn't that actually the problem? Because the Supreme Court in the recent Andrews decision put it in the positive, not in the double negative. And we have the gloss of 2254 D1. And so isn't the question whether or not the evidence that we can say that the Oklahoma Court of Criminal Appeals unreasonably determined that the evidence was not so unduly prejudicial as to render the trial fundamentally unfair. And in order to accomplish that, we have to do more than overcome a double negative. To overcome the possibility that it may have tipped the scales, we have to affirmatively determine not only did it tip the scales, but nobody, fair-minded jurors, as Judge Phillips mentioned, could find otherwise. And so we have basically, I think, 3 layers that we have talked about. I think you talked about with Judge Phillips, with the phrase in the Supreme Court's opinion in Andrew, that it has to be unduly prejudicial. Do you agree with, I think, the premise of Judge Phillips' question, and that is we have to consider the impact of the improper evidence as it relates to the legitimately considered evidence? So if it's overwhelming evidence that was legitimately presented, that was exclusive of gender, that we have to take it into account under the remand instructions. Do you agree with that?
Yes, Your Honor.
And then we have to take into account I think the very first question Judge Hartz mentioned, and that is, you know, if you look through the question of Mr. Oslow's testimony about didn't somebody call her a hoochie, objection hearsay sustained. You know, we have to then consider if, even though it wasn't stricken, if that objection is sustained, can that be so unreasonable on the OCCA's part that in applying plain error, or at least they should have applied plain error, that would unreasonably taint the fundamental fairness of the trial, right? We have to consider whether there was a contemporaneous objection, right?
Yes.
And then we have to consider, I think under Wellman, whether or not the direct appeal presented those arguments, just like the example that if you make arguments to us, can we say, well, the district court didn't, you know, consider that, but, you know, they didn't have the benefit under the party presentation rule. So it seems like you have sort of a triple difficult burden under D1. You have to overcome the lack of a contemporaneous objection to much of this evidence. I don't know that there was any evidence, any objections to the sexualized nature of the evidence. There were Burke's objections, there were relevance objections, but none of the objections that were presented to Judge Bragg seemed like the same objections you're presenting to us. And then you have, you know, the problem in Wellman, that how can we say that an argument was unreasonably dismissed by the Oklahoma Court of Criminal Appeals when they didn't have the benefit of that argument? Seems like a very difficult burden when you have those layers that are, you know, entrenched into 2254 D1. I know that's a long compound question, but that's, to be honest with you, that's just what I'm struggling with. So if you can kind of help me out.
And the burden under D1 is high. We completely recognize that. The no fair-minded juror standard is a hard one. It's also been expressed as D1 relief is reserved for extreme malfunctions of the criminal justice system. And I would call this case an extreme malfunction of the criminal justice system, where a defendant has been condemned to die in a trial that was so flooded in judgments, debasing testimony about her as a woman. And nevertheless, with the D1 standard, we maintain that no fair-minded jurist could have reached this conclusion when looking at the evidence in the context of the proceedings as a whole at both guilt and penalty phases, because of how this evidence is compounded by testimony that comes in day after day, because of how the state used its own evidence, opening the case with this, closing the case with this, leaving jurors right before deliberations at both phases with images of Miss Andrew as an adulterer, which was condemned from the first day. That the fundamental fairness of this trial is beyond dispute, and the framework of the sex stereotyping continues to pervade this case. They still haven't got away from that, which I think shows the power of this kind of testimony. So absolutely D1 is a high bar, and I have no qualms arguing before you that this case does arise to that. It is so extreme.
You'll get 5 minutes for rebuttal. Do you have any questions now?
No, thank you.
Thank you, Your Honor.
But when you have the 5 minutes, it's to respond to the government's arguments. It's rebuttal.
Thank you.
Okay, now we're going to listen to the prosecution side try to tell us why it was okay for them to sexualize this woman when she was on trial for murder. Okay, let's listen carefully. Wow.
Ms. Crabb?
Good morning. May it please the court. I'm Jennifer Crabb, Assistant Attorney General, excuse me, for the appellee. I plan to begin my argument by focusing solely on the evidence that was contested in front of the Court of Criminal Appeals. I may, depending on how the argument goes, get to the proper scope of the evidence, and of course, at any time, I'm happy to take the court's questions
The
about
proper
that.
scope, huh?
The guilt stage in this case lasted 17 days. The state called 50 witnesses, and its case alone, not including voir dire, including opening statements through the state's witnesses, was 3,250 pages. The contested evidence covered approximately 26 pages of that, 26. On the second day of trial, which is the day that Mr. Higgins and Mr. Nunley testified, 20 pages out of 300 was devoted to the contested evidence. And beyond that, there were 3 days where there were 2 pages. The red hair, Ms. Larson's testimony about her suspicions that Ms. Andrew had been unfaithful with persons other than her father. And so that's it, 26 pages out of, yes.
The statement was made, I think in that brief, that every day there was evidence of this. I didn't read all the forensic evidence thoroughly, but it seemed to me there were days when there was no reference to sex in any way. It was forensic evidence, finding the gun in the neighbor's attic, the trajectory of the bullets, whether she could have shot herself, things like that. Was there, when you've gone through about where the contested evidence was, were there days when there was nothing about that?
There were many days where there was nothing about that. There was the 5th day, the 6th day of trial. The 7th day, there were no witnesses. It was a very brief transcript, no witnesses. The 8th day, the 9th day, the 10th day, the 11th day, the 13th, and the 14th. On every one of those days, there was none of the contested evidence.
Well, not just contested, maybe at the time, but contested now. Were there any references that they're complaining of during those days?
I'm going to have, so I didn't specifically note everything that is now contested. However, I can just give you an overview. For instance, day 5 of the trial, the witnesses were related to the insurance policy. Somebody from Prudential. They were Mr. Andrews' divorce attorney, Craig Box, There was the woman who worked with Mr. Pravat, who it appears that Mr. Pravat used her notary stamp for some paperwork. And then there was the somebody who was higher up at Prudential talking about the policy. That was the 5th day of trial. The 6th day of trial was a continuation of the Prudential employee. There was the taking of writing samples from Mr. Pravat to compare to the confession letter. And then there was handwriting expert David Parrott. That was the 6th day of trial. So certainly, again, I can't tell you with absolute certainty that none of this was referenced in cross-examination or anything like that. But the focus of most of the days of trial was on the evidence of guilt and not anything aside from the motive being sexual.
Can I, did you have a follow-up? Isn't the counter argument to that, and I can't remember the great aphorism from Chief Justice Roberts, toxins can be deadly in small doses. We're talking about a murder that happened, not yesterday, but 24 years ago, November 20th, 2001. And isn't it the elephant in the room that trial was absolutely laden with nothing but gender, including from the trial judge, telling the defendant in the middle of trial she can't wear pantyhose. It's saying that you can't wear makeup because you're really pretty. It would be different if you weren't pretty. It's hard to imagine that a county judge would say that to a male defendant. That you can't wear cologne because you're already a really handsome guy. This is a case where we start with, as I think your adversary pointed out, we start with a lengthy marriage, but it starts with college. These are grown individuals, and then when Rob goes to visit her in college, he finds out that she was sleeping around. They weren't married, and then finds out that she had cheated on him another time before they were married. There are episodes where, how many times did she go to bed with, what's his name, Tracy Higgins in the car, where they had sex in, what reason could there possibly be, even if it were relevant, but to say what was the overarching lesson from that trial? This woman is terribly promiscuous. She does not deserve your sympathy. And I think it's really hard to overlook that. I mean, I think you probably, I'm not trying to put you on the spot, but I think anybody listening to that trial or reading the trial would think no male would ever have encountered any of that. Now, you have good arguments. Maybe it might have been the same thing if parts of those, if the defendant were assigned a role as a controlling male, maybe it wasn't gender related. But then again, a flat affect for a male, how many times did the male, screw his mistresses in the car? This was an atrocious trial.
I respectfully, very strongly disagree with that, Your Honor. I would start by just reminding Your Honor of the proper scope. The idea that some toxins are deadly in small doses was not an argument that was made before the Court of Criminal Appeals. The argument in the Court of Criminal Appeals was not focused on the sexual nature of other crimes evidence. As I pointed out in the brief, the proposition covered all kinds of alleged other crimes evidence. But as far as the tenor of the trial as a whole, and that's what I spent the last several days doing, is rereading the entire trial. And it's very isolated. The references that are improper are very, very isolated. And I don't.
You know what? Let me ask you a question. Well, they're just isolated. The improper was just isolated. They shouldn't be there at all. That should have never happened. There's a due process problem here. And they're just skating all around it. It's shocking, actually, that let's just keep watching. I do have her 2007 appeal pulled up that we are going to look at, where it starts talking about the crime itself. But right now, I'm just focusing on the disgusting sexualization of the defendant during her own murder trial. Here we go.
Agree, the demeanor, we cited cases in our brief where it was used against men. I'm old enough to remember Scott Peterson, and that was one of the biggest red flags that led police to suspect him, was his lack of care that his wife was missing. And so I don't agree that that's gendered, and I very strongly disagree that that was the focus of this trial. Now, I will also put it in the context of what the defense was. The defense in both stages was a character defense. As I believe Judge Hartz pointed out, or maybe it was Judge Phillips, Mr. Nunley was asked by defense counsel, you think she was a good mother, right? Yes. You don't think she was the type of person that would do this, do you? No, I don't. Defense counsel talked about where Mr. Andrew had written in his journal that Brenda Andrew was a good mother and she was the spiritual leader of the house. Ron Stump was asked by defense counsel, you told me you think that Miss Andrew is a good Christian woman, right? Yes. And that's all first stage evidence. And we quoted extensively in our brief from defense counsel's opening statement, where it is, they met in college. Guess what? Petitioner was going to a Christian college, but guess what? She got pulled away from her Christian college by Mr. Andrew. And then she was, living her best life, one of the best employees her company, her bank had ever had, until guess what? Mr. Andrew pulled her away and made her move. And then she did it reluctantly. She rebuilt her life, and then guess what? Mr. Andrew made her move again. And so character was the foundation of the defense in both stages of this trial.
But some evidence you acknowledge was irrelevant.
Yes.
And your position is, yes, it was irrelevant, but it didn't matter.
Correct. Absolutely. In light of the overwhelming evidence that the court has acknowledged several times is there. We went through it, a lot of it in our brief, but frankly, it wasn't even all of it. Barbara Mercer Green, who worked with Mr. Andrew, heard Miss Andrew say, if you file for joint custody, I will see you dead. Also, that I'm not afraid to do whatever I have to do to keep the children from being with you. The plumber, Mr. Head, overheard petitioner tell Mr. Andrew, I'm going to kill you or have you killed. We know that she asked Mr. Pabat to kill him, or if there was somebody who would do it for her. Rod Lott said that Mr. Andrew told her that Brenda wished him dead. She was having him stalked. She knew what time he left his apartment, things like that. She was calling him 30 to 40 times a day, harassing him.
When the stalking wasn't to find when it would be easier to kill him, it was to see whether he was himself having an affair. Isn't that right?
That's correct, Your Honor, but it is also relevant to her motive, her absolute obsession with Mr. Andrew and getting him out of her life, and particularly out of her children's lives. She told her friend, they are my children, they're not his, and I don't want them to have a relationship with him. Yeah. So that was an overwhelming motive that has.
I'm going to stop right here, and we're going to go over here, and I'm going to read to you exactly what evidence they did have against her. And again, hold on, my eyes kind of itchy. Sorry, guys. A lot of people make statements, but they don't really mean it. It's just like, well, a lot of us have said, I'm just going to kill that person, but you're not serious about it. You're just in a casual conversation, maybe using the wrong words, but we do it all the time, but nobody ever really thinks that somebody's going to do that, right? So, especially now you're over here, they're trying to get divorced. They're both fighting over the children. The whole scene right there. So let's go ahead and take a look over here. I'm going to leave the scene as this while I read the appeal real quick. I'm only going to read the parts of the crime itself, because to me, that's what's important. The underwear, the affairs, none of that's important. It's what she did or did not do. Here we go. So we're not going to start at the very top. We're just going to go start at top. Okay, now this is the opinion. Now this is from the state of Oklahoma, and this is from 2007. So this is 6/21/2007 that this was decided from her first direct appeal. So here we go. A jury trial was held before Honorable Susan W. Bragg, District Judge, in June and July of 2004. The jury found the appellant guilty of both counts and found the existence of two aggravating circumstances. The murder was for remuneration, which is money, and the murder was especially heinous, atrocious, or cruel. The jury set punishment at death on the first-degree murder count and 10 years and $500,000 fine for the conspiracy count. Now, Judge Bragg formally sentenced the appellant in accordance with the jury verdict on September 22nd, 2004. The appellant's husband, Rob Andrews, was shot to death at their Oklahoma City home sometime around 7 p.m. on November the 20th, 2004. The appellant was also shot in the arm during this incident. Then it goes, the Andrews were separated at the time, and Rob Andrews was at home to pick up the two minor children for visitation over the Thanksgiving holiday. The custom was that the appellant would bring the children out to the car and Rob would take them from there. However, on this night, the appellant asked Rob Andrews to come into the garage to light the pilot on the furnace because it had gone out. The appellant's version of the events from the point was that Rob was trying to light the furnace when two masked men entered into the garage. Rob turned to face the men and was shot in the abdomen. He grabbed a bag of aluminum cans to defend himself and was shot again. The appellant was hit during the second shot. The undisputed facts show that after that, appellant called 911 and reported that her husband had been shot. Emergency personnel arrived and found Rob Andrews' body on the floor of the garage. He had suffered extensive blood loss and they were unable to revive him. The appellant had also suffered a superficial gunshot wound to her arm. The Andrews children were not, in fact, packed and ready to leave when Rob Andrews arrived. They were found in a bedroom just watching television with the volume turned up really high, oblivious to what was happening in the garage. The appellant had taken to the local hospital for treatments. Her behavior was described by several witnesses experienced in dealing with people in traumatic situations as uncharacteristically calm for a woman whose husband had just been gunned down. Rob Andrews was shot twice with a shotgun. A spent 16-gauge shotgun shell was found in the garage on the top of the family van. Rob Andrews owned a 16-gauge shotgun, but had told several friends that the appellant refused to let him take it when they separated. Rob Andrews' shotgun was missing from the home. One witness testified seeing the appellant at an area used for firearm target practice near the family's rural Garfield County home 8 days before the murder, and he later found that 16-gauge shotgun shells at that site. Appellant's superficial wound was caused by a .22 caliber bullet, apparently firing at close range, which was inconsistent with her claim that she was shot at some distance. About a week before the murder, Fabat purchased a .22 caliber handgun from a local gun shop. Now, Jana Larson, Fabat's daughter, testified that on the day of the murder, Fabat borrowed her car and claimed he was going to have it serviced for her. When he returned it that morning after the murder, the car had not been serviced, but Larson found one round of a .22 caliber rimfire ammunition on the floorboard. In conversations later that day, Fabat told Larson never to repeat that the appellant had asked him to kill Rob Andrews and that he threatened to kill Larson if she did. His own daughter. He also told her to throw away the 22 round that she'd found in her car. Police searched the home of Dean Gigstead, the Andrews' next-door neighbor, after the Gigsteads reported finding a suspicious thing in their home. Police found evidence that someone had entered the Gigsteads' attic through an opening in a bedroom closet, and spent 16-gauge shotgun shells were found on the bedroom floor, and several .22 caliber rounds were found in the attic itself. There was no signs of forced entry into Gigstad's home. Now, Gigstad and his wife were out of town when the murder took place, but the appellant had a key to their home. The .22 caliber rounds found in Jana Larson's car was the same brand as the 3 .22 caliber rounds found in Gigstad's attic. The .22 caliber bullets rounds were capable of being fired from that firearm that Pavitt had purchased a few weeks before the murder. Further testifying, it was not possible because the gun was never found. Okay, well, the 16-gauge shotgun shell found in the Gigstad's home was the same brand as the 16-gauge shell found in Andrews' garage. Ballistics comparison shows similar markings indicating that they could have been fired from the same weapon. Now, whether these shells were fired from the 16-gauge shotgun Rob Andrew had left it at the home was impossible to confirm because, as noted, the gun remains missing. Within days after the shooting, before Rob Andrews' funeral, the appellant, James Pavitt, and the 2 minor children left the state and crossed the border into Mexico. They were apprehended while attempting to re-enter the United States late February 2002. Appellant and Pavitt met while attending the same church. At some point, they began teaching Sunday school together. Appellant and Pavitt began having a sexual relationship. And it says 3 around the same time. Okay, 3. Pavitt, a life insurance agent, assisted Rob Andrew in setting up a life insurance policy through Prudential worth $800,000. In late September 2001, Rob Andrew moved out of the family home and the appellant initiated divorce proceedings a short time later. Jetta Larson, Pavitt's adult daughter, testified that late October, Pavitt told her that the appellant had asked him to murder Rob Andrew. On that night of October 25th to 26, 2001, someone cut the brake line on Rob Andrews' automobile. The next morning, Pavitt persuaded his daughter to call Rob Andrew from the untraceable phone and claimed that the appellant was at the hospital in Norman, Oklahoma, and needed him immediately. An unknown male also called Rob that morning and made the same plea. Now, Rob Andrews' cell phone records showed that one call came from a payphone in Norman near the Larsons' workplace, and the other came from a payphone in South Oklahoma City. Rob Andrew discovered the tampering with his car before placing himself in any danger. He then notified the police the next day. Appellant told Rob that she read in the newspaper that someone cut his brakes, but no media coverage of this event had ever occurred. Okay, now let's go back and finish listening to this. Now that's interesting, isn't it? So, and I understand that none of that really matters in this case because there's plenty of other evidence that shows exactly what happened, right? So, but it still didn't need to happen. But let's finish letting the prosecutors talk. Here we go.
Nothing to do with her affairs, as well as, of course, the $800,000. She got angry when a witness suggested that, well, when you get divorced, maybe you just get a part-time job. And she was angry at the idea that she might have to do that. She wanted that money.
Let me take a quick legal detour for a couple of questions. Sure. Page 15, you talk about Chapman as though that fits within our analysis. Chapman doesn't apply here, does it?
Your Honor, it's not entirely clear because the Court of Criminal Appeals did say that the evidence that it found to be wrongly admitted was harmless.
But not harmless beyond reasonable doubt, which would be required for Chapman, right?
True, but it is not clear from the language of the Court of Criminal Appeals whether they were saying it was harmless as a matter of state law or whether they were saying it was harmless in terms of the due process analysis. Now,
other places, they use those magic words, beyond a reasonable doubt, for harmless. There they did
sure.
not.
Sure.
So are you really asserting Chapman?
I think it's relevant. I think that you can look at the cases where it's been argued that they misapplied the prejudice prong of Strickland because they use differing language at different points in the opinion, and you can't necessarily infer, but I don't need Chapman. Certainly under 2254D and the Supreme Court's decision, the fundamental fairness analysis, we still win.
And second legal question, do you acknowledge or agree that the Supreme Court, in the opinion that sent us here today, has said that pain does apply to the guilt phase, even though it was a sentencing phase case?
Yes.
Okay, thank you.
Sure.
Judge Phillips, I don't want to talk over. Do you have a follow-up question?
No.
I just want to make sure I understand the answer to the first question of Judge Phillips. I'm still not clear why Chapman or Brown versus Davenport would have anything to do with this, unless this is an alternative argument to affirm, assuming that we credit the petitioner's claim under D1 and D2 and determine that it was not a fundamentally fair trial. Are you saying that my alternative argument to affirm is under Brown versus Davenport and Chapman that the denial of a fundamentally unfair trial would have been harmless beyond a reasonable doubt?
No, Your Honor. My argument is that the Court of Criminal Appeals found the admission of some of this evidence to be harmless.
I get that, but how does that but if you're not arguing harmlessness as an alternative argument to affirm, I guess I'm just not understanding how Chapman or Brown versus Davenport fit into the element of whether or not the evidence was unduly prejudicial so as to create a fundamentally unfair trial under a remand instruction.
Right. I think I see two ways to look at the way this court is analyzing this claim. And the first is pain. But the second is that the Court of Criminal Appeals found constitutional error, but found it harmless. And in that case, this court's review would be under Chapman and Davenport. Because
which is solely harmlessness, not, they don't address a fundamentally unfair trial, right?
Expressly, that's correct. But we know that they decided the merits of the due process claim. And so it's unclear from their opinion when they said harmless, were they saying this shouldn't have been admitted as a matter of state law, but it was harmless?
Okay.
Or were they saying this may have constituted federal constitutional error, but if so, it was harmless, in which case this court's would be Brown versus Davenport.
Okay, thanks.
Sure. I think I'll hit on a couple of points responding to petitioner's counsel's argument. Judge Johnson's dissent, I would submit to you that that is not a proper indication, at least not a complete indication of the claim that was exhausted. And for that point, I would point you to the Donald Grant case and also to the Scott Eisenberg case. In both of those cases, the dissenting judge raised an argument that hadn't been raised by the majority. And in one case, it was specifically like, was this exhausted or wasn't it? And this court said that we can't rely on the dissent to tell us whether something was exhausted or not.
Okay, so your argument is that this claim is unexhausted.
The claim as it is currently presented, yes.
All right, didn't Moore versus Showman in 2002 specifically say we cannot deny relief on the merits of the 2254 claim based on some claims? Judge Murphy called it a hybrid adjudication, and dismiss other claims without prejudice for non-exhaustion. And his rationale, as I recall, was that now what do we do with the second or a future petition? Is it second or successive? Well, how do we say that if we ultimately say that the unexhausted claims were dismissed without prejudice, which is what we'd have to do? So isn't your argument of non-exhaustion of this claim specifically foreclosed by Moore versus Showman?
Your Honor, I'm not familiar with that case. However, I would say that you can deny a claim on the merits even when it's unexhausted.
That's right, but not because of an exhaustion. Then we'd have to reject it on the merits. And if it was unexhausted, how can we say that the Oklahoma Court of Criminal Appeals adjudicated the claim on the merits if I thought the Oklahoma Court of Criminal Appeals abided by the party presentation rule as we do? But if you're right, isn't it an anomaly that you're saying, well, that this claim was unexhausted? Well, your whole argument under in applying D1 or D2 assumes that it was adjudicated on the merits. Well, how could this fundamentally unfair trial claim have been adjudicated on the merits if it wasn't exhausted?
It wasn't exhausted because when under Donald Grant, as for one example, when you so change the nature of a claim with new evidence, new arguments, new case law, then there may have been a claim that was exhausted in state court, but that is not the same claim that is now in front of this court.
Yeah, and so, but that's, I guess, I don't mean to beat a dead horse, but isn't that the problem? You know, the theoretical anomaly of your argument is you're saying the claim that these petitioners are presenting to us was unexhausted, and yet, because they transformed the claim from what had been presented in the direct appeal to the Oklahoma Court of Criminal Appeals. And yet your argument on D1 and D2 presume that the claim that they are presenting to us was adjudicated on the merits. Well, how could the Court of Criminal Appeals have adjudicated the claim on the merits of the claim that they're presenting to us if it had never been presented to them?
I think Your Honor recognized when you cited Wellman that the claim that's presented now is not the one that the Court of Criminal Appeals adjudicated.
But isn't that, isn't Wellman the only way you could address that? And to apply Wellman, you would have to assume, Because Wellman, Wellman deals with the application of D1. So wouldn't, to apply Wellman, we have to reject actually what you just said, and that is they didn't exhaust it. They did exhaust it, which would be a precondition of applying Wellman versus CBOC. Do you understand what I'm asking?
I think I understand, Your Honor, although I don't know how you can reconcile that with Donald Grant and the fundamental changes to this claim. I certainly agree, I'm willing to set aside, although not waive, set aside for the purpose of this discussion, exhaustion. But I would say that under Sexton versus Boudreaux and under Wellman, this court is still limited to the arguments that were made to the Court of Criminal Appeals.
What is the basic principle behind exhaustion?
To give the state court a fair opportunity to decide the merits of the claim.
And you're saying because there was no reference to this particular evidence or the closing or things like that in the presentation to the OCCA, that those portions, at least, of the claim were not exhausted. Is that your position?
That is, and I believe Gray versus Netherland says that the facts, in order to exhaust the facts, do have to be before the state court. Now, I understand that this court has held, and I think the Supreme Court as well, that, a fact or two here or there that doesn't significantly change the nature of the case doesn't implicate exhaustion. But here we have far beyond that.
And does the same argument, and it's not just the fact, but you have to say that you can't say before the OCCA that evidence was inadmissible because it was hearsay, and now give a different argument for why it was.
That's correct. Yes, the arguments, the facts, the focus, the degree of focus. Was this Burke's? Is the state case? Was this Burke's evidence, other crimes evidence, or was this an all-out assault on Miss Andrews' femininity? Those are also very different focuses.
Wow.
I want to kind of put in context for the court how incredibly difficult it's going to be for a petitioner to establish a right to relief on this claim. Under Oklahoma's statute, section 2403, which mirrors this court's 403, the admissibility of evidence, and not as a constitutional matter, but just the admissibility of evidence, you have relevance and you have unfair prejudice. And evidence can be admissible even if it's more unfairly prejudicial than probative. It has to substantially, to be inadmissible, the prejudicial effect has to substantially outweigh the relevance.
Are you suggesting that we can review that decision?
Yeah, no, I'm not. I'm just, I'm going to go on to the next two layers to explain how difficult the standard is in this case. But then you go beyond that to the fundamental fairness analysis, right? And you may already have this. Well, to prove a fundamentally unfair trial, you have to prove that the prejudicial nature so overwhelmed the irrelevance that it rendered the entire trial fundamentally unfair. But this case has a third layer, and that's AEDPA. And so then the question is, is it the case that no fair-minded jurist could conclude that we didn't get to hear to the, so substantially outweighed that she was denied a fundamentally fair trial? And we submit, in light of the evidence in this case, particularly the overwhelming nature of guilt, and our position is the very limited nature of the improperly admitted evidence, that petitioner cannot meet that threshold.
What about the failure to provide limiting instructions? That needs involved in that analysis too, doesn't it?
It does, and this court, the Court of Criminal Appeals addressed that and found it harmless. This court addressed it in its first decision and also found it to be harmless. And the jury wasn't completely left without any guidance. There was the instruction in both stages that told them that they were not to render their verdict based on sympathy or prejudice, except in second stage they could have sympathy for petitioner. So they were told that. Defense counsel made the point, look, what the state's trying to do here is they're trying to make you think that she's guilty by making you think that she's a bad person. Don't, basically the implication was don't let them do that. Look at the evidence. And the state's closing arguments sure, they referenced affairs. They had to. It was part of the motive in this case. But the state's closing arguments did not focus on the contested, irrelevant evidence, not in the least. And I don't think that I can do any better, than to say what this court already said in this case, which is as to cumulative error. Now, this first part that I'm talking about, this court did not consider the irrelevant evidence because you had found a lack of clearly established law. So I'm going to caveat it with that, but you found it evident that the trial was fundamentally fair. And you said that you were confident that she was not, the cumulative error relief was not required. You found that the errors were of minor significance when viewed against the backdrop of the entire proceeding and the overwhelming evidence. But you didn't leave it there because you also, the majority responded to the dissent. And the dissent had found cumulative error based on the evidence that's contested today, the lack of the instruction, 3 excluded defense witnesses, which aren't before the court anymore, that's law of the case, and a Miranda violation. So all of that, and the dissent's review was de novo. And this court said in footnote 56, even if the dissent's unprecedented approach were justified by a Supreme Court holding, we would still rule that the overwhelming evidence of Ms. Andrews' guilt would outweigh any harm from the dissent's combined constitutional violations. And no, you didn't phrase it in the negative. We would still find that the unfairly prejudicial effect didn't so overwhelm the relevance as to establish a fundamentally unfair trial. No, you said that the overwhelmingness of guilt would outweigh any harm. So the inverse.
Is that law of the case?
That is a very good question, Your Honor.
No.
I believe, yeah, no.
So far, it's 1-1.
Right.
Let me ask you a question about limiting instructions.
Sure.
Does it matter whether limiting instructions were requested by the defendant?
They were requested. I don't believe
for
it.
all of the evidence we're talking about, they asked for limiting instructions on all of it.
They didn't at the time the evidence was introduced. They did ask for limiting instructions, I believe at the beginning of the trial and certainly in the instruction conference. Now, I don't recall, whether they specifically pointed it to each item of contested evidence. Of course, a lot of it wasn't even objected to at trial. However, state law does require the instruction to be given, even if not requested. Now, it's not clear, too. The state had argued that some of the evidence was res gestae, for which the limited instruction is not required. So when the Court of Criminal Appeals found error in not giving that instruction, it's not clear which particular pieces of evidence they were pointing to, but even assuming that all of the evidence that is properly before the court and that was improperly admitted is considered with the lack of the instruction, this court has already determined that was harmless.
Did the trial judge give any response to why she didn't give the limiting instruction?
Not in great detail. The state objected, said that it was res gestae. I presume that may have been, but that's a presumption on my part.
She didn't add anything additional.
Correct.
She just okay.
Correct. That's right.
Would a limiting instruction have been required in every instance on count 1, the conspiracy count? In other words, do you see what I'm saying?
As to I'm sorry, I'm not following.
That it wouldn't be 403. It would, for the conspiracy, to be evidence of the crime.
Probably not with respect to the affairs with Mr. Nunley and Mr. Higgins. Certainly much of the evidence that established the relationship between petitioner and Mr. Pravat.
Okay, let me see Leslie what she's saying. Yeah. If she was a man, his sexual history and affairs would be overlooked. You're exactly right. You're exactly right, Leslie. That's why this is important. And yes, we know based on the evidence, yes, that her and Mr. Pravat did this together. We know that because I'm going to read you something else in just a minute. But still, this should not be part of this. And I'm just shocked that it was ever even, it was even brought in. But then when you think back about 20 years ago or 22 years ago when this actually, or 23 years ago when this actually happened, well, actually it's been 25 years, right? 2001, when this actually happened, and you talk and you think about people in general, I mean, in the Bible Belt of the United States of America. Think back about that, and then you'll understand, oh Lord, yeah, men were always treated differently than women when it came to that type of activity. Okay, so we'll finish listening to this real quick, and then we're going to go back and look at the other parts of the fact. Here we go.
Was helpful to establish the conspiracy, yes.
Mm-hmm.
If the court doesn't have any further questions, we would respectfully ask you to follow what you did in your first opinion and to affirm the district court's decision. Thank you.
Thank you.
Now she has to rebuttal her 5 minutes.
We just have 3 quick points, Your Honour, and I don't want to try the court's patience discussing things we've already been talking about. First, the state continues to argue there that this case wasn't really about sex stereotyping, and nothing could be further from the truth. Counting up days on one side that have more evidence of gender bias and days on another is not the inquiry that's before this panel. It's the fundamental fairness of the whole proceedings.
You did say in your brief, though, that every day.
Yes.
Is that accurate?
Yes, Your Honour. We've provided the string site with examples of those every day. I'm afraid I don't have every day at the tip of my tongue, but day 11 was one that was cited, for example. On day 11, Dean Gigstad was testifying about whether or not Miss Andrew went skinny dipping in a hot tub on her property, and the prosecution followed up with another question about whether she was skinny dipping. That evidence cannot but put an image of her body in the minds of jurors, and our brief has a string site as to other examples.
Let me ask a question. Now, this is the neighbor. How does the neighbor know she went skinny dipping in a hot tub on her property? Was he over there looking over the fence? Was he stalking? What's going on over the neighbor's house, right? That leads to a lot of questions. Here we go. Jeez.
That came in every single day. Second, the state acknowledges that this case was about Miss Andrews' character. We agree it was about her character as a woman and her transgressions on the basis of an immutable trait, and there it has to be limits to what
the argument here was that she was the one who raised character. So the fact that it was a trial regarding character, if that's how the defense frames it and is arguing that she was a good wife, a good mother, a good Christian, etc., that is important to the context of what the state is arguing, is it not?
Yes, Your Honour. And Miss Andrew cannot open the door to things that came in in the state's opening argument. And the structure of the state's case was about far more than responding to a comment. Was she a good? It's a 2-word question. Good mother. He confirms good mother. This is none late on at the start of trial, and nevertheless, before all of that, there's the testimony from Mr. Higgins, which we talked about. We don't need to go over that again. But saying that the flooding of this trial with gender bias, with evidence designed to sex shame her, by saying that she opened the door to that with one question, I think is not an argument that holds water here. And my third point is the limiting instruction. On page 105 to 106 of the trial transcript is the first time that the defence requested a limiting instruction, and specifically requested it with respect to the affairs, and asked that the trial judge instruct the jury on the permissible inferences that they could draw about Miss Andrews' affairs. I don't have anything further, so if there are no questions from the panel, we would respectfully ask that this court remand, grant the writ, and order issue for a new trial for Miss Andrews.
Thank you, counsel.
Thank you.
Oh, wait, go.
It's really not a substantive question. It's really a record question, because one of the things that I was looking for, because both of you disagree about a particular recording call and whether or not you could hear Brenda Andrews' voice on the recorded call on November 19th, the day before the murder. There was differing interpretations of whether or not you can hear Mr. Andrews coaching Tricity. I looked for the audio, and I don't know if that's, I know obviously part of the trial court record, it was played for the district trial court. Are you all confident that that is in our record? I may have overlooked it.
I'm afraid I haven't heard that recording, Your Honour, but we can absolutely look for that and submit a 28-J letter advising if it's part of the record.
Yeah,
Please do so.
Yeah, thank you.
All right. So you know what happens next.
Thank you, counsel. The case was very well argued. Makes our job just that much harder. Thank you. Counselor excused and court is adjourned.
All right. So we're going to take that off of there. Now let's go back over here. Let me tell you what I got over here. I'm going to tell you some more about what happened, because I know that some people are like, oh, well, it doesn't matter. She still did all of this. I get it. But I mean, when you are using sexualization, I just think that the way they approached this was totally wrong. And she did get it. It was re-looked at, but then later it was overturned again. So there was a 2007 appeal, and then there's the one from 2025. But let me tell you about 2027 over here. This is when this first started on her appeals. Now, we talked about what happened, that they, they found the gun, they found these bullets in the next door neighbor's house, and that she had a key to the next door neighbor's house. So listen to this here. Okay. Let me go back where I was. Okay. Now so police searched the home. That was the next door neighbor. Within days after the shooting, before Rob's funeral, the appellant, James Pavat, and the two minor children left the state and crossed the border into Mexico. They were apprehended while attempting to re-enter the United States in February of 2012. The appellant and Pavat met while attending the same church. Okay, so what I'm telling you here is the cruelness here is the children were not even allowed to go to their father's funeral because they were on the road with the two people that took their father's life. So this is just incredibly cruel. Okay, so let me go back down here. All right. So then they leave, and they're apprehended when they're trying to come back into the United States. And let me see what else. The appellant did not attend her husband's funeral, choosing instead to go to Mexico with Pavat and the children. Pavat called his daughter several times from Mexico and asked her to send them money. Now, Larson cooperated with the FBI and local authorities in trying to track down the pair. After her apprehension, the appellant came into the contact with Teresa Sullivan, who was a federal inmate at the Oklahoma County Jail. Sullivan testified that the appellant told her that she and Pavat killed her husband for the money, the kids, and each other. Appellant also told her that Pavat shot her in the arm to make it look like she was a victim. Expert testimony opined that the wound to appellant's arm was not self-inflicted, but was part of a scheme to stage the scene to make it look like she was a victim, just like her husband. Additional facts will be discussed as relevant in the appellant's propositions of error. Then they also tried to do a change of venue. Now, in the Proposition 10, which is the errors from the trial, appellant claims the trial court erred in not granting her a request for change of venue. Prior to her trial, appellant had filed a motion for change. The trial court held that a hearing on the motion on January the 9th and the 21st of 2003. The defense presented evidence to the extensive coverage of the case in the local media, as well as polling data showing that a substantial number of Oklahoma County residents were somewhat familiar with the case and had opinions about the case. After considering this evidence, the trial court denied the motion, stating, "I don't think we're going to know whether an unbiased juror can be seated until such time as we bring in a large panel, put them into the jury box, and then voir dire them. It's unfortunate, but this is actually the only way that you can make that determination." So I'm going to get down to the bottom. I'm just going to read you. I'm not going to read the whole thing right now because we don't really have time. We've been almost 2 hours. But I think it's very important to hear the audio of the arguments. So let me get on down. I'm gonna get down here to the bottom where it actually tells us what they decided. Okay, so Brenda Andrews, appellant, was tried before the jury for her crimes of murder in the first degree and conspiracy to commit murder in the first degree in case number CF 2001-6189 and the District Court of Oklahoma County before the Honorable Susan W. Bragg, and the appellant was sentenced to death for murder and 10 years and a $500,000 fine. On the conspiracy court, she perfected this appeal and the judgment and sentence is affirmed. Okay, so it was affirmed and that was it. It's over. Now that's what happened the first time around. So then there's another appeal filed. So the next thing that happened is there's another appeal filed, right? So the audio you just heard is from that appeal. And let me show you, now I'm going to show you the news as to what happened in that appeal. So hang on a second here. Hang on a minute. Let me get back over here to this. This was 1 year ago. So hold on, guys. Let me share my screen and let me share the screen over here. Hello. All right. Share the screen. There we go. Now.
Right, she thinks evidence about her sex life wasn't fair. Now a lower court will look at the former Sunday school teacher's case.
When I was an intern in law school, I actually sat through much of the trial, and I specifically remember how much the prosecution focused on Miss Andrews' sex life, how much they focused on how bad of a mother she was.
OKC attorney Ed Blau saw the trial himself.
Brenda Andrews was convicted of conspiring to murder her husband.
Rob Andrew was killed in 2001. His wife Brenda, a former OKC Sunday school teacher, was found guilty of working with her lover, Jim Pavat, to plot and kill her estranged husband. Court documents say an $800,000 life insurance policy was purchased by Rob Andrew through agent Jim Pavat.
Many people are surprised to know that somebody can be given the death penalty if they are not actually the person who caused the victim's death.
But in a Supreme Court ruling Tuesday, justices ordered a lower court to take another look at her case over 20 years after she was convicted in the murder.
Regarding her sex life, regarding her qualities as a mother, whether or not that evidence that should not have been given to the jury, whether it rose to the level of violating her due process rights.
The 10th U.S. Circuit Court of Appeals in Denver, Colorado, will now review Andrews' claims. Blau says it's possible she could be resentenced at the end of all this, or she could possibly get a whole new trial. It comes down to this question.
As to whether or not that evidence was unfairly and unduly prejudicial and therefore violated her constitutional rights.
Now, it is possible that court could take no further action at all. In Oklahoma City, Jason Berger, KOCO 5 News.
Let me get rid of that. Whoops. Oh, wait a minute. Hang on just a second, because that was, when was this? Okay, that was that one. Now there's another thing I'm going to show you that was from that's from this year. Now this just happened in 2026. Let me get it pulled up for you. Let me see, that is that right there. Okay, so I've got to find, let me go back and get this other, what happened on April 27th of 2026. Let me pull this up right here. Hang on. Pull it up. Now, this is going to be the update on this situation. All right, let me share my screen with you so you can see what's happening here. Okay, here's the updates. 4/27 and 26. Brenda Andrews filed a petition today seeking a rehearing from the 10th Circuit, asking the court to overturn her conviction and death sentence due to rampant gender bias during her trial. After obtaining an historic win at the Supreme Court in January of 2025, the court remanded the case to the 10th Circuit to evaluate the prejudicial evidence presented in Ms. Andrews' trial. On January the 13th, a panel of judges for the 10th Circuit Court ruled against Ms. Andrews, holding that her trial was not fundamentally unfair. Making that decision, the panel just failed to comply with the Supreme Court's instructions on remand, refusing to consider that most of the sexist, prejudicial evidence presented at trial and misconstrued Supreme Court precedents in order to deny Ms. Andrews relief. The petition filed by Mrs. Andrews today argues that the panel just disregarded weeks of prejudicial testimony influencing jurors and their perceptions of Mrs. Andrews' credibility, her defense and narrative, and ultimately the value of her life. In order to correct this error, her petition asked the panel to rehear the case, or in the alternative, for the 10th Circuit to hear the case in bank. Okay, so she was not happy with what she was given. And so that is that. So she's asked for it to be looked at again. And I don't think there's been anything updated about that since then. So I need to go out. Let me go see if I can find, hang on a minute, guys. Let me pull this up over here now. This was just the, not that long ago, but 10th Circuit. Okay, hang on just a second. Okay, of Brenda Andrews. Hang on just a second, guys. Okay. Okay, I've got to find the right date here because there's so many things about this case over here. It's just, okay, let me find 2026. All right, hang on, guys. I don't think she's going to win. I don't think she's ever going to win this case because there's so much damning evidence that her and Pavatt did this together. And even though it's not mentioned really in her case, he did confess to it. Okay, January the 13th. Let's see. That was filed on the 13th. Hang on just a second, guys. Oh, on May the 4th, let's pull this back up right here. Whoop. Now, let me share my screen over here so you can see this. We're going to be getting off here soon. I just want to finish talking about this because it's a very, they tainted the jury and she should have had a new trial. Even if she would have still been found guilty and been given the death penalty because of what she did, she still should not have been sexualized by the court system, and that's exactly what happened. But let's go ahead and read this. We're going to read this, and then we'll be, done with. Okay, is this the right one? Hang on. Right here. Here we go. Now, news. This is from May the 4th, 2026. Counsel for Brenda Andrews asked for a rehearing in the 10th Circuit based on rampant gender bias. On April 27th, counsel for Oklahoma death sentence prisoner Brenda Andrews, the only woman on the state's death row, filed a petition asking the U.S. Court of Appeals for the 10th Circuit to reconsider whether her constitutional right to a fair trial was violated by the prosecution's use of rampant gender bias. Now, during her trial in January 2025, the U.S. Supreme Court, in a decision, remanded the case for consideration of whether the state's gendered evidence was so unduly prejudicial that it rendered her trial fundamentally unfair and unconstitutional. Now, in January of 2026, a panel of the 10th Circuit judges ruled against Ms. Andrews, finding that the gendered evidence presented at trial did not undermine her right to a fair trial, and that the fair-minded jurors that the fair-minded juror could doubt inspection of the trial with unfairness. Now, with this conclusion, the 10th Circuit upheld denial of habeas relief, and counsel's new petition for rehearing alleges that the panel failed to comply with the Supreme Court's instructions and alleges that the panel, and disregarded weeks of prejudicial testimony that influenced the jurors' perceptions of Ms. Andrews' credibility, her defense, and ultimately the value of her life. Now, during Ms. Andrews' 2004 trial, the murder of her husband, the prosecution called witnesses to testify about her provocative clothing, it's just terrible, and previous sexual relationships, and questioned out loud whether a good mother would dress or behave in that way. Now, the way that Ms. Andrews had, the state alleged that Ms. Andrews, along with James Pavatt, a fellow member in their church, fatally shot Robert Andrews and offered circumstantial evidences of her involvement. Mr. Pavatt confessed to shooting Mr. Andrews and maintained that Ms. Andrews was not involved in her estranged husband's death. In their arguments to the jury, prosecutors called Mrs. Andrews a hoochie and a slut puppy. That's just disgusting. They opened a suitcase and showed the jury Mrs. Andrews' underwear, asking, "The grieving widow packs this. Is this in her appropriate act of grief?" The prosecutor held up a thong and lace bra in front of the jury and stated that a grieving widow doesn't pack her thong underwear and run off with her boyfriend. Ms. Andrews' jurors sentenced her to death in In 2025, the ruling that the Supreme Court noted, the state spent significant time at trial introducing evidence about Ms. Andrews' sex life and about her failings as a mother and a wife, much of which it later conceded was irrelevant, including testimony from her previous sexual partners, evidence of the kind of clothing she wore before the crime, as well as attacking her fitness as a mother. It's just everything is wrong about this, everything. Now, following the Supreme Court's 2025 remand, the 10th Circuit held oral arguments and held that Mrs. Andrews had not challenged the introduction of much of this evidence in question during her state appeals, and therefore the state court could not have erred by not taking into consideration this evidence that she did not introduce. It's the 2026 opinion the 10th Circuit panel wrote. Fault the Oklahoma court. They could not fault the Oklahoma court for not searching the records to support Mrs. Andrews' claim. Ultimately, the panel concluded that the alleged stereotyping did not substantially undermine the fundamental fairness of the trial. Attorneys for Mrs. Andrews argued that their new petition that the panel failed to consider the cumulative effect of the gender-based evidence and conducted only a partial review that excluded the significant portions of the sex stereotyping record, including testimony about Mrs. Andrews' alleged affairs during college and sexual partners 2 decades earlier. Her attorney also contended that the panel looked too narrowly at isolated pieces of evidence rather than assessing whether the trial as a whole was fundamentally fair. The petition additionally questions the 10th Circuit's reliance on its own 2020 precedents, Wellman versus Colorado Department of Corrections, which the panel used to limit its review to only arguments that Ms. Andrews raised during her state appeals. Her attorneys described Wellman's as irreconcilable with the Supreme Court's remand instructions and are asking the 10th Circuit to limit or overrule it altogether, seeking a hearing before either the same panel or the full court. So there you have it. This is what happened. Let me get rid of all these. I have too many things open. Hang on, guys. Let me get rid of all this. All right. Here we go. Get rid of that and get rid of that. And here we go. So there you have it. This is what happened in this case. Hey, allegedly Andrew, how you doing? You're sidetracked, glad. Oh, so glad to see you. Listen, I would love to hear your take. Allegedly Innocent is a psychologist. She's a trained psychologist. She's here in Texas, and I just love to watch her show. I would love to hear her take on what happened in this court case, because I can't, for me, see what happened to her as they paraded her underwear around, her suitcase that was on her when they found her at the border and took her in, to me was just ridiculous, and it's overstretching. Yeah. Oh, no, allegedly sweet, innocent. No, I mean it, because I love listening to her talk about these cases, if you have not seen her channel, let me go ahead and give you her. I'm going to pull this up over here really quick, and then we're going to be saying goodbye. But anyway, so I need to give you her. Hang on, come on, her channel. Oh, why is this doing this now? It doesn't want to act right. Okay, so let me go to Allegedly Innocent and pull her up. You've got to go listen to her talk about these cases. She is very, very smart. I love watching her. Here we go. Let me pull her up, and I'm going to share her channel. Just a second, guys. There we go. Let's see, share. This part right here, share. Copy that. All right, put this over here. There we go. I'm not real good at this, but anyway, here we go. Let's get this over here. So go out and sub up to Allegedly Innocent and listen to what she has to say about these cases. She does true crime, that kind of thing. And she's trained. I just love listening to her. Anyway, we have been on here for, let's see, a little over 2 hours. I think I gotta get going. So yeah, I'm gonna do it at the beginning. Thank you for going back and listening to the whole thing, because this case is terrible, and I want you to give us your insight on it. Like when you could do a show and give us your insight on this situation, because sexualizing the defendant in a murder trial and then never allowing her to have this corrected is fundamentally unfair, and I think she was prejudiced against, because when you got a bunch of Bible thumping, so this is 25 years ago, jurors over in Oklahoma, and they're seeing her cheating on her husband and all the other things that she was doing. She never stood a chance in hell. Now, we know she did it. We know why she did it, but you still have to give a fair trial. That's the Constitution. That's your right as an American citizen. And this is the only place in the world that I know of that you are guaranteed to get a fair trial. So with that, I'm going to say, Goodbye. Anyway, we'll talk to y'all later. I think Sprinkle Donut and I are going to come back and we're going to do a live together and we're going to compare Gypsy Rose Blanchard to Casey Anthony, because even though they don't have the same crime, they have a lot of the same traits, a lot of the same trying to rebrand themselves and all that kind of things about those two. So we're going to come back and do that on Friday. I can't do it on Thursday because I have to have a little procedure. Because anyway, it's a whole long story, but we'll do it on Friday. I'll announce the time. So yeah, it's a very conservative state. Right. And Oklahoma, you know it is. It's interesting. Thank you, Leslie. Thank you, Leslie. I appreciate everybody stopping by. Listen, just hit that like button. Just hit that subscribe button on your way in or your way out. For so long, I have forgotten to ask people to do that because I did not recognize the importance of it until somebody told me, that's how your work gets into the algorithm. And I was like, no, I didn't really understand that, because I'll tell you, when I jumped onto YouTube, I had no idea how hard it really was and what it took to actually become monetized. For some reason, I thought they just got up there and had a good time talking to each other. But it's real work, and I'm telling you, the successful channels, they work hard. They do work hard. There's another channel y'all need to go check out. She's doing an excellent job on the Guthrie case, and that is Guilty of Crime. That's another one I like to watch. And, I mod for Clutched in Pearl, so I always like to talk about Justin, too. So y'all take a chance, go out there and look at all of them. If I had more time, I'd just go I need to get a list and start dropping these channels. I always forget to do that. Anyway, with that, I want to say goodbye, good night. Hey, be careful out there. Take care of yourself. Go hug your babies. Life is short and our time with them is even shorter. Think about that. Bye, guys. Have a good evening. Thank you so much.